Recording.
Okay. My name is Angel Cushing. Now I'm going to do this tonight is introduce Mr. Professor Roger McGowan. And then after Professor Roger McGowan speaks, we'll have Tatum come in and I'll address any issues or questions that might come up while you're thinking about the information I just give you. The information that I have for you is the good news that Trego County passed a resolution against the Kansas-Nebraska Heritage Area Partnership and passed a resolution against 30 by 30. Absolutely fantastic. Yeah. What that did for us was initially on the legislative level is they held a hearing, they called and held a special hearing on December 8th and 9th of 2021 for 30 by 30 and property rights. They've done absolutely nothing with the information that they got from that. So the next time you talk to your legislature, please encourage them to come up with some ways. They have several very good suggestions on laws that can be passed, such as requiring a Kansas legislative vote on national heritage areas before they can be introduced into the state of Kansas. While national heritage areas are federal, and technically the state of Kansas cannot stop them, what they can do is deny funding to any national heritage area that is not approved by the state legislature or doesn't get that vote. So that's one idea, and there are several others on conservation easements and general property rights that can be considered. So as of right now, there are 45 counties in the Kansas-Nebraska Heritage Area Partnership that have passed resolutions not wanting to be in that national heritage area. 45 out of 49, which is fantastic, fantastic. The Freedom of Information request that we got showed us that they started lobbying Congress about 5 years prior to us discovering them. So 5 years they went to your federal legislatures and your state legislatures and told them that you wanted a national heritage area. For anybody that doesn't know what a national heritage area is, national heritage area is a federal jurisdiction that's voted on by Congress. It creates a map and it grants federal jurisdiction over that land. Once that federal jurisdiction is made, it comes with a federal land management plan. If you want an idea of what those looks like, Kansas already has a national heritage area called Freedom's Frontier National Heritage Area in the eastern part of Kansas and western part of Missouri. 7 of those counties, when we started doing meetings here last year for you all, we accidentally started notifying people down in Freedom's Frontier National Heritage Area. And my phone started ringing. And I got 2 very common questions. The first was, does this have anything to do with the stricter regulations that are coming into my area? And the second question I got was, why wasn't I told? Why didn't I know about this? Why didn't they inform me? Since then, 7 of those counties have passed resolutions wanting out of Freedom's Frontier National Heritage Area, and I am preparing to ask Congress to reduce that boundary down to Douglas County. At least that was my plan until this following weekend when I took some phone calls from folks in Lawrence County or Lawrence, Kansas, who said, hey, we don't want this here either. So I'm not quite sure what the plan is, going forward with that. I want to tell you that if you recall when you were here last year, Tatum came out to our meeting and spoke. We had a lot of legislatures that came to our meeting last year. Tatum was super, super fantastic, and she was a champion for us. In fact, she's the one that kicked that off. When she heard that Lyon County was trying to ban barbed wire fences, she called me up and said, do you have a national heritage area over you? I said, no, not at all, absolutely not. And she said, okay, but I'm going to put you in touch with people that know how to fight these things. It turns out that my county did try to join a national heritage area at the same time that they were trying to come up with the regulations that would fit so nicely in that federal land management plan. Sure, it's just a coincidence. The good news, before I continue on Tatum, the good news that I wanted to tell you is as of right now, as of May, in fact, or about the first part of June, Kansas-Nebraska Heritage Area Partnership pulled down their Facebook page. Oh. They canceled their YouTube channel and they have went dark and went silent. 4 or 5, I think it's 5 of their board members have resigned prior to that point. They have not announced that they're no longer pursuing a national heritage area. Normally, when they quit, either the National Park Service or the National Heritage Area itself announces that they're not going to pursue them. They have not made that announcement, so we are not considering them dead until they do. The National Park Service has been quiet. My last Freedom of Information request on them showed no communication with Kansas-Nebraska Heritage Area Partnership. So those are all very good signs. That comes with your effort and the county's effort with those resolutions, and I thank you for that. Back to Tatum. Tatum opened these doors and created those relationships by just simply calling me up and asking me questions. And that resulted in the meetings that we did last year through the spring. That also resulted in an introduction to Professor Roger McCollum. And he's a professor of Washburn University. And I called him up, and I promise, I'm going to make this clear right now, I'm going to not plagiarize it. I steal a lot of his information. I'm not going to plagiarize it. This is my first time hearing him speak. I look very, very forward to it. I did read a lot of his blogs and a lot of his publications. He is published. He's a specialist in agriculture, law, and taxation at Washburn University. And in addition to being an author, he has a radio broadcast as well, correct?
National Daily Syndicated Show and 2 other programs.
There you go. Thank you. Thank you for helping me out with that introduction. I appreciate it. So I'm going to turn it over to Professor McCohen, and then so at some point Tatum should be coming in, and we'll let her speak after.
Okay. Thank you, Angel, and thanks to everybody for coming this evening. She mentioned the radio shows. How many of you have heard the Daily 2-Minute Show? A number of you have. That's on numerous farm radio stations in Kansas, 193 stations from coast to coast, plus Sirius XM multiple times a day. So about 100 times a month you'll hear it on Sirius XM. 147 is the channel that airs on rural radio. But I've been on WIBW every other Monday for 27, 28 years. I think I've just eclipsed pretty close to 800 programs with them. And then every other Wednesday on KFRF, on the K-State Radio Network. So many of you probably heard that. That's been 27, 28 years on that too. I do travel the country, coast to coast. This is not a one out and back. I'm speaking all day tomorrow in Hayes for attorneys and CPAs at the Western Kansas Council on Giving and Estate Planning. So that meeting is all day tomorrow in Hayes, and then back home for a few days, and then off to Durango, Colorado for 2 days, speaking all day long. So it's a 16-hour. You get about 45 minutes tonight. If you'd like 16 hours of technical stuff, you can come to Durango, and then off to Kennewick, Washington, and back to Denver, and out to Montana, and up to North Dakota, and then we'll get to about mid-August after that. So I'm always pretty much on the go, and in the meantime, when you see the blog writings and so forth, I may be in a hotel someplace, I may be at home, I may be across the country someplace writing those. And here's the address for that. If you're not familiar with that, that's my web address, washburnlaw.edu/Walter, W-A-L-T-R. It stands for the Washburn Agricultural Law and Tax Report. And on the home page, down the left-hand side, is where you can find the link to my blog on the Law Professor's Blog Network. It's called the Agricultural Law and Taxation Blog. And if you're into Twitter, this crowd may not be a Twitter crowd, I'm not sure. But there's my Twitter handle, and if you're on Facebook, that's the name that you want to look for Facebook. Either my personal name or that. They're both the same. I use Facebook and Twitter purely for educational information to get that out. I'm not posting pictures of what I had for supper. I have a niece that did that, and we're no longer friends on Facebook. Probably because some sniping comments that I make concerning that. I thought she didn't take kindly to agricultural connotations to what her food looked like. You kind of get my drift as to what my comments are. I've seen those before. It's not so served on a plate. It's amazing how fast, how sensitive people can be, even family members. But anyway, so washburnlaw.edu/Walter. There's my email address. Feel free to contact me anytime you have questions. I try to get them answered as soon as I can, especially during tax season. I get backed up with easily 100 a day questions, so it's tough. And my wife is here with me this evening. She drove me out, and she can tell you we do not have much depth of conversation or any conversation when she's driving me out, because I'm writing something or answering emails or researching something or getting ready for the next event. And tonight I've got to sort my slides together for the 8-hour presentation tomorrow. They're all there, I just have to rearrange. So that's probably not tonight, but early in the morning, 4 a.m. But nevertheless, and I find this interesting because there was something in the news just this evening on the way from the hotel in Hayes to here that's pertinent to our discussion tonight. Something the administration is trying to do today in terms of an announcement that they made that dovetails right in with what I'm going to talk about tonight. Now, the normal way that legislation is made, if you want to think back into the 1970s, I think everybody here can remember the 1970s. Do you remember that program on Saturday morning, Schoolhouse Rock?
Yes.
Remember the educational show that was there in between cartoons as to how a bill was made?
Yes.
You remember that? You know, there's a great attempt to try to not do that approach these days.
Yes.
And that's what happened again today. The administration made an announcement, well, forget Senator Manchin, too bad we can't get a bill through Congress. I'm just gonna do an executive order, we're gonna ram this stuff through. Never mind what the US Supreme Court said about 3 weeks ago. I'm gonna talk about that in just a moment. They're doing trying to do an end run around what the Supreme Court said. And they basically said, one of these senators said today, well, we're just gonna ram all this stuff through. If the court knocks 1 or 2 of them out, we'll still get something through. Wait a minute, that's not the way the system is supposed to work. So what's going on? What's been going on? What's under the surface? That's what I want to kind of peel back this evening and show you. And everything I'm talking about tonight is on my website. I've written about it, I've put it out there, I've published it. And so I want to start out by talking about the public trust doctrine. It's probably not something that you've ever heard of unless you're really digging into the weeds on this stuff. But this is the legal theory that's out there that they're using, some activists are using, law professors are using. I have a colleague at the law school that is deeply enmeshed in this and filing amicus briefs in various cases. I'm on the other side in some of those same cases, which makes it pretty interesting. He has not won any of those. I have, so I kid him. I said, I sure hope you don't get paid for the advice you give. Failing. Go back out on the road. But the public trust doctrine, what is it? Well, it's actually nothing new. It's just wrapped in a new blanket. It's a centuries-old theory predating the Magna Carta, which is one of our founding documents, one of the documents behind our founding. But the doctrine says that the seas, the oceans, were viewed as the common property of everyone, and so they were not subject to private use and ownership. So they were deemed to be held in public trust for the use of the public. Okay? That's the basis for this. So the seas didn't belong to anyone. You can't possess them. You can't have a deed to them. You can't treat them as your private property. They're to be used for commerce by everyone. Okay? That's the ancient doctrine that's out there. That's where the public trust lingo came from. So it's many centuries old. That concept was later adopted by the drafters of the Magna Carta, which again was one of the documents that founded this country. And it became part of the common law of the colonies and then the initial 13 states after the Revolution. Okay. So what does that mean? Well, certain things belong to the public at large and can't be owned privately. Well, that primarily applied in the United States, after the country was formed, access to seashore and intertidal waters. That's what it was limited to. We have to have the public to have access to the waters, to put a boat out there so that you can put a fishing boat out there and harvest fish or do whatever in the sea. So you have to have access to the seashore and intertidal water. Seems pretty innocent. That was the initial view as to the scope of the public trust doctrine. Now, the issue now is they're trying to use that theory and expand it to get access to private property, to take private property rights, and do an end run around the Fifth Amendment of the U.S. Constitution, which is the takings clause, which says that the government can take your property if they want to, but they have to do what? They have to pay you for it. Okay. Well, if we have a way around that, then they can take your property without paying for it. Keep that thought in mind. So any expansion, whether it's by courts, or whether it's by Congress, or whether it's by a state legislature, results in curtailing or stopping, pulling back vested private property. What's a vested private property? It's a right that's been there, that you've had for some time. The law has recognized that. Some of you may have in Kansas what's known as a vested water right. Okay? There's no question that that's your right, that's your private property. It belongs to you with respect to that land. That's a big issue. This whole thing is a big issue for agriculture, because if we're curtailing vested property rights with respect to agriculture, that's land, that's water, that's air, that's minerals, anything that you can privately own. And a lot of those are major resources with respect to agricultural operations. We need those resources privately owned. We need to be able to convey them, we need to be able to buy them to operate efficiently. Okay, the first application of this public trust doctrine by the U.S. Supreme Court was in 1842, Martin versus Lessee of Waddell. And the question was, well, who owns the land underneath that is submerged off the coast of New Jersey? And that was a question that came up because oyster fishermen were concerned about that. Well, who has the rights to fish the beds of the coast off of New Jersey? The land at issue, the court said, belonged to the state of New Jersey for the benefit of the state. And so the state could license people to go out there and fish, they could regulate that somehow, but that was deemed, under the public trust doctrine, that the ocean, the off the coast of New Jersey, was deemed to be owned by the public at large, so by the state on behalf of the public, and then it could be used as regulated by the state. That was in 1842. Illinois Central Railroad case, 50 years later, back in the Supreme Court, the Supreme Court again said the government cannot interfere with public rights to access land under navigable waters. Now, note the distinction here. Under navigable waters, if it's non-navigable waters, that's private property. You own the beds of that as the overlying landowner. But if it's navigable waters, then the bed is owned by the public. We got some case law on that in Kansas. There was a case about 30 years ago in southeast Kansas, down near Pittsburgh, where you had a farmer that owned both sides of Shoal Creek, owned the land on both sides. The creek went through his property. He didn't like canoeists coming right through the middle of his farm, so he fenced it. He ran a fence across there and stopped the canoeists. And somebody came down in the middle of the night and caught themselves in the fence. The court said, too bad, he owns both sides. He can fence across that because he owns the bed of a non-navigable stream. And you can't do that across the Mississippi, you can't do that across the Missouri. Those are navigable water courses. In Kansas, the Kansas River is a navigable water course. But a stream that's going through your property, you run a fence across that. Same theory is going on here. Except the court said for situations where the land involved wouldn't interfere with the public's ability to access the water or impair navigation. So again, it was just very constrained doctrine, only applied to access to water. Other applications of this, however, would be preservation of oil and mineral resources, preservation of fish stocks, crustacean beds. Many lakes and navigable streams are maintained under the public trust doctrine for purposes of drinking water and recreation. Okay? And that historically has been the limitation of the public use doctrine. For drinking water supplies, for recreation on navigable streams, And if it's a coastal water, that's deemed to be owned under the public trust doctrine by the state that is the adjoining state to that water, so that they can regulate the use of that for private purposes. Okay? Now, when we talk about the Fifth Amendment, because any expansion of this doctrine is gonna chip away at private property rights, then we have to think about the Fifth Amendment. The Fifth Amendment says the government can take your property, but they have to pay for it. They have to pay you just compensation. That's the takings clause of the Fifth Amendment. And that's a fundamental constitutional right because it's one of the first 10 amendments to the Constitution. And so any law that Congress passes or a state passes that infringes on a fundamental constitutional right is looked at pretty closely by the courts. That's subject to what we call strict scrutiny. It's a very high hurdle that the state or the federal government has to overcome to be able to have that law be deemed to be constitutional. Okay? So that deals with ownership of private property. So private property ownership is a fundamental constitutional right under the Fifth Amendment. Subject to any law that impinges upon private property is subject to strict scrutiny. Okay? Meaning it's gonna be pretty tough for the government to say, we've got a reason we need to take this property and not have to pay for it. But they do have the eminent domain battle. They can take it, but they have to pay for it. And a lot of the battles on Fifth Amendment takings cases are on level of compensation. Okay. Now, the proponents that for the expansion of the public trust doctrine, really what they're doing here is they're trying to do an end run around the just compensation clause of the Fifth Amendment. And this is the key to understand this. I'll break it down as simply as I possibly can here. And this is the frustrating, this is, by the way, the frustrating thing for my research assistants. I have law students that do research for me, and I'll have them write up a case or research an issue. I said, no, you gotta boil that down, way down. I get this stuff, and I said, no. Forget everything they taught you in first year of research and writing. I don't want that stuff. And I had one student, one of my research assistants about a month ago, she just started for me, and I get this 2.5-page summary of a case. And so I reworked the whole thing, and I put it in a script for my 2-minute daily radio show, which is actually I have 82 and a half seconds, from start to finish, to talk about what she wrote. It took her 1,500 words. And I said, okay, here's what you gave me in 256 words. When you read a case, what you're trying to do is tell a story. What is this case about? Why is it relevant? And remember this when you get out there and you have clients. They don't care about all this flowery stuff. Tell them how it affects them and why they should care about it. And so they're learning that. And one of my other students went with me to Columbia, Missouri last month, where I was speaking all day, and she heard me speak for 8 hours, and she said, I just had a year of law school. I think I learned more in the last 8 hours than I did in the past year. Get to the point and move on. So here's the key point on this. If the government has to pay for what they're taking, is there a way to get around that requirement? And this is where they're using the public trust doctrine. Because what they're saying is, the theory is that public rights pre-existed any private property rights. So the public rights pre-existed, and private property rights are automatically subject to the pre-existing public rights under the public trust doctrine. Therefore, we're not taking anything from you. You didn't have it to begin with because the public trust doctrine was there first. Okay, that's the argument. So the technique has been tried in multiple cases, and this has really ramped up over the past 4 or 5 years. Multiple cases across the country, some big cases in California, a prominent case in Nevada, I'll show you, a prominent case in Iowa last year, I'll talk about that one in just a moment, to get courts to decide allegations of harm and restrict usage of private property based on global warming or climate change. There's this existential threat that is out there, and that's always what they say, well, there's an emergency. That's your code word. What did you hear today in the news? President said, well, there's an emergency. Global warming is an emergency. I have to do an executive order. What are they doing? Not going through Congress, not going through the courts. They're not waiting. They're just doing it. Okay, well, we're protecting the public at large. Well, no, you're not. You're taking property rights without paying for it. Is what you're doing. That's what this is. Okay? Courts have largely rejected this. No, 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 no. Based on a lack of standing, you can't do these things just because it makes you feel bad. You know, or it makes you feel good if you're protecting the, no, no, no. You can't file a lawsuit based on your personal feelings. That's why the courts have said, no, you don't have standing. You don't have real injury in fact that the courts need to address, because they'll say this is a political question. If it's a political question, Congress has to answer that. The state legislators have to answer that, not the courts. The courts stay out of it, and that's largely what they have done. And so the courts have largely rejected the cases either because there's no standing to bring the case, or because the Congress didn't delegate the right of an administrative agency to deal with this particular issue. And I'll get to that Supreme Court opinion in just a moment. And the courts will say, it's a political question, we don't deal with political questions. That belongs with the politicians, the elected representatives, okay? Not some unelected bureaucracy. The courts will say, no, out. And so largely the courts to date have resisted the expansion of the public trust doctrine. Now it's not to say they've done that everywhere, okay? But largely the courts have said no. And many of these cases at the state level, they look back to state law and they say, well, the legislature here has said that we have a narrow, tailored public trust doctrine, and until the legislature expands it, we're not going to do it. And that's a key. That was a key in the Iowa case. So this is a quote in one of my articles on the blog. It said, the notion that vested property rights can be usurped by an expanded application of the public trust doctrine makes it easier for regulation of property rights to occur without any concern that a non-physical taking of the property has occurred that would require the private property owner to be compensated. That's what they're trying to do. Get around that requirement under the Constitution. They're trying to get around the constitutional protection of private property by the public trust doctrine, by saying, well, what we took was a right that you never had to begin with. That's pretty radical. That's the argument. So you need to be aware that is being argued in a number of cases. You know, some pretty prominent law firms are making those arguments, and they may be saying, well, in terms of its application, it might be the Endangered Species Act. We have to have minimum stream flows in a river under the public trust doctrine. There may be limitations on irrigation water. This was a Nevada case that my colleague at the law school was in, arguing as an amicus brief that under the public trust doctrine, farmers and ranchers in Nevada should be subjected to strict limitations on the amount of irrigation water. Well, no, the court rejected that. They said, no, that's up to the legislature in water law policy to do that, not the courts. But that's how they try to do this. If the doctrine is expanded, it would require the state and federal governments to take action to preserve public rights, and if they fail to do so, the legal system would be used to force action. Okay. And that's been a tactic. If you can't get legislation through, this is why the Supreme Court nominees over the last 30 years since Robert Bork have become so politicized. Because you have one side of the aisle that wants to do legislation through the courts. And so now every judge becomes politicized, and it just becomes horrible. But that's what they're trying to do. And you hear this talk about, well, we need to expand the Supreme Court, the size of it. Well, why? Because they can't get done through the normal process of getting a bill through the Congress, so we're going to politicize the court and back the court. That's what that discussion's all about. It's all kind of the same thing here. The court becomes then something of a super legislature, a court packing technique that's off the radar, out of the public view, and not subject to elections. Okay. So expanding the doctrine would apply to farmers and ranchers in numerous areas. What about endangered species on private land? Well, we need this species out there for the public, therefore you can't engage in certain farming activities that would harm the habitat of that species. Now, did they go through the Congress under the Endangered Species Act and the regulatory agency to promulgate a rule under the Administrative Procedures Act, put it up for a hearing, take comments, and follow the process? No. Just say public trust doctrine and run it through the courts and see if you get a court to approve. So they're changing the process here. What about vested property rights for crop irrigation, livestock watering? It's a bypassing of the legislative process. Again, their argument is, we didn't take anything because you didn't have a right that we took. Government, we're just getting an easement for the protection of certain designated natural resources that are deemed to be in the public interest. We're not actually taking the property right. Well, yeah, you're getting an easement, but by virtue of getting the easement, I'm restricted in what I can do on my property. So, yeah, it's 6 of one, half dozen of the other. And also, the expansion of the doctrine will decrease an incentive of landowners to invest in and improve natural resources. Well, one, why would I want to buy land that's subject to all these types of restrictions? I can't do anything on it. I can't profit as much from it as I could. Some of that value has been taken from me. And I would, if I have it, I wouldn't invest resources to improve it if I'm not going to be able to recover that. So that would be the theory there. Recent cases, this is a Nevada case 2 years ago. This is a water rights case. The court said the public trust doctrine had already been implemented in Nevada by virtue of their water law, the prior appropriation system. So we're not going to expand it beyond that because that was the public trust doctrine, the state's water law. And the legislature, and this was key, had expressly prevented the reallocation of water rights that had not otherwise been abandoned or forfeited with state water laws. I said, no, we dealt with that through water policy. If you want to change the rule, you've got to go back to the state legislature and have them change the water laws. That's the way the process is supposed to work, not by some court changing water law and restricting rights. This is a big case last year out of Iowa. I don't know if you followed this. This has gone on in Iowa for the last 10 years. There have been a group of activists that have tried to put more limitations on farmers in Iowa in the Raccoon River Valley Basin. From northwest Iowa, the Raccoon River goes to southeast Iowa. It is the water source for Des Moines. So it's got a big urban area on it that supplies the water for. And there's a waterworks company in Des Moines that water comes down the Raccoon and they clean it up and it becomes drinking water for Des Moines. And they tried to say, well, under the public trust doctrine, we need to have more limitations on farming practices so that there's less nitrogen and phosphorus that's getting into the Raccoon River, because they couldn't get it through the legislature or the state DNR. I said, no, we have appropriate restrictions. They're following the guidelines from the Land Grant University and putting in all types of practices and suggestions for farmers. But the legislature said, if we go any further than that, then we're taking private property rights. We can't do that. And so here come the activist group and say, well, under the public trust doctrine,